Welcome, everybody. Thank you for joining us today. Um, I'm Chris Capel. I'm a partner here at Husch Blackwell in our intellectual property group. Before we begin, we're going to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use to today's program. If you have any questions during the webcast, which we encourage, please submit via the question box, and we will try to answer them as we go along. If not, and a full answer is needed, then we'll follow up by email with you. A PDF of the presentation is available in the resource folder. This program has been approved for legal education credit. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of this webcast. If you would like to watch it again or share it with others. Toward the end of the program, be sure to complete our short survey. We use the feedback to plan other programs, and in fact, that's how we got the idea for this program, was from some feedback we got last year after one of our seminars. That's all the housekeeping items, and we're going to go ahead and get started today. I've got with me Liam Riley and Myers Dill. They are both associates in our intellectual property group here at Husch Blackwell, and all of us work. We're all also registered patent attorneys, work on trademarks, but a lot of what we do is working on technology agreements, software licensing agreements, joint development agreements, joint venture type agreements. Those are a lot of what we work on a day-to-day basis. I'll let each of them introduce themselves a little bit. Liam?
Yeah, as Chris said, intellectual property attorney here at our Kansas City office. My time is spent fairly evenly between what I think some would consider traditional IP, patents, and trademark work, and then a lot on the technology side, like Chris said, with technology agreements, software license agreements, and primarily in the healthcare and education spaces, although I've done work with other clients as well. Fun story I like to share is when I joined the firm almost 4 years ago, there was a huge demand for software agreements and technology agreements. So this is something I've been working on since day one of my practice. And so I've really come to enjoy it. Enjoy making it a part of my practice.
Yeah, absolutely. So yeah, I'm Myers Dill. I would echo substantially what Chris and Liam said from a practice standpoint. My kind of different feature, I guess we could call it, as opposed to them, is so I'm in the technology, manufacturing, and transportation business unit. So I work with a lot of clients in those particular industries, and I am in the St. Louis office, just here seeing my friends in the Kansas City office for the first time in a while, which is really wonderful. That's kind of my deal.
Great. So I think one of the things, like I said, that we've, both Myers and Liam and myself for years have given software presentations and software licensing or technology licensing agreements. And we've always done the whole agreement, the anatomy of a software contract or the anatomy of a joint development agreement. And so today what we thought we would really focus in on are the areas that we tend to find we spend the most legal time really talking about in a negotiation, either talking about first with clients and then also with, and representing clients, representing vendors. And then what is it that when we're in the negotiation, either, like I said, when we're talking to our clients first and explaining these issues, or when we're going to, negotiate, we find that we spend most of our legal time in terms of what we're talking about and negotiating on warranties, representation and warranties, indemnification, and limitation of liability, which also kind of ties in insurance. Which we'll touch at the end as well. But those are the three main topics we're going to go through today. And that way we felt like we really, people have asked us several times, like, oh, this overview is great, but I'd really like to, if you guys want to dive into some of the meatier parts of, the agreement, rather than just always kind of talking about, scope and some of those business terms. So definitely want to kind of dig in. We're going to start with representations and warranties. We're generally going to have we're going to try to have this be a little more conversational, so please do send in questions if you have them. But we're going to take this from, Liam is really going to kind of take it from the client customer perspective, and Myers is really going to talk about it from a vendor perspective. That way we can kind of cover both areas. We're going to really dig into the representations and warranties, what each of them are, what you can ask for, what do we typically see when we get an agreement, what are the kinds of things we're adding and why are we adding them? And, one of the things that really we see is that typically it's always going to be on vendor paper. We usually, if we're representing the client, we get that, document from the vendor and we review it. We do have clients that have their own forms. That is sometimes tough because a client form isn't always going to fit that particular piece of software or the hosted services or other professional services that we may get. So we really spend a lot of our time looking at different agreements. But I can kind of always tell you, I know I've looked at so many of them throughout the years that, a software contract is really going to have kind of these pieces and parts. It's usually in about the same order. So usually about 3/4 the way in, 2/3 or 3/4 the way into an agreement is where you're going to find these sections. And by then, some clients' eyes have already glazed over. So then once you're into these sections in particular, people really don't necessarily want to, it's just a lot of legalese. And so it's our job is to help break down that legalese, make sure, our clients are getting what they need in the agreement, either, or if it's a vendor, not over promising something or putting in capabilities that the vendor doesn't really have. So those are the ways we're looking at that. And in particular, the reps and warranties are so important because from a client perspective, that's obviously the obligations that you're putting in the agreement to make sure either the software is going to work or what happens if it doesn't work and those kinds of things. So I'll let Liam and Myers kind of start taking over in terms of discussing some of the reps and warranties that we look at in terms of software and the contract to start with.
Thank you, Chris. Yeah, I think that was a good overview and description of representation of warranties. I like to think of them as kind of contractual promises, maybe sometimes used to induce customers to sign on to an agreement in certain ways, and also have certain consequences associated with it. And I also think of the topics we discussed today, and as you can see on the screen, this is just software-related reps and warranties. There's a long list of reps and warranties that we can put into an agreement, and some are more applicable in certain situations than others. And I think it kind of goes back to a lot of kind of considerations I'll touch on here shortly, but a lot of times we'll get questions such as, send me a form license agreement. And it's just really difficult to conceptualize and capture everything we need to in a single type of form agreement, especially when it comes to reps and warranties. So for example, some of the initial questions we ask out the gate to our customer and the vendor is it software or is it professional services or both? If it's software, is it hosted or is it on premises? If it's hosted, who's hosting the data? What kind of sensitive data do we have, if any? Is this mission critical? Is this interoperable with other aspects? And to Chris's point with the reps and warranties providing kind of a promise and getting what you want from the vendor, also understanding that if this solution is replacing another solution, perhaps we can address some shortcomings of the previous vendor through the reps and warranties as well. So that's just a short list of 6 or 7 questions that I had. But from that, we can kind of identify and think about what the reps and warranties we want to see in this particular agreement between this particular arrangement with the customer and the vendor. So I think to start just briefly, some of the more standard ones that we'll see a lot of times in technology agreements are availability, uptime warranty, just when will the software solution be available and when can I use it? Performance, and is it the performance of the solution going to be consistent with documentation as provided? Maintained functionality, which is basically there will be no adverse decrease effect in the functionality over time despite any changes. IP infringement, and title and ownership, basically the vendor owns what's provided, and then legal compliance. That's kind of what we would expect across the board in these technology agreements. And I think now I'll turn it over to my vendor counterpart to kind of talk about why some of those might not necessarily be an initial draft of agreement, or if by the customer present them, how we might respond.
Sure. So from the vendor perspective, if I have my vendor hat on, I'm thinking about the notion of these being promises. And so I'm thinking, are these promises that I can fulfill myself, i.e. my team can fulfill, or are these promises that are maybe even being fulfilled for me by a third party? And so from my perspective, in keeping with the spirit of keeping a promise, I'm looking at whether this is something I can reasonably uphold my end of. So when we're looking at something like availability, uptime, actually, when we're looking at any of these reps and warranties, my initial position is going to be as is, right? I'm giving this to you and I don't want to make a lot of promises. Now, it's a very extreme position. agreements don't end up that way typically. But that would be sort of my far opening position. And when we get into the specific reps and warranties that Liam brought up, again, I'm thinking of it from the perspective of what can I do? What can I hold a promise and maintain that promise? So on the availability uptime warranty, that's one that we have a lot of fun conversations about, because typically on the vendor side from a form, you would see an availability percentage of whatever the deliverable is that's being provided at something maybe like 99.5%. And at first blush, I think that looks like a really pretty number. That's if this were a test, that's a good number to have. But what I think when you do the math, that's 3.5 hours of downtime. And so a month, right. So I might get some pushback on that number to move it up to something closer to 99.9, which cuts that downtime by a substantial amount down to about 45 minutes.
And something in kind of that regard as well is we see a lot of vendor contracts that say 99.5, and sometimes that could be acceptable to the customer depending on how mission critical it is. But to Myers' point, 99.5 is 3.5 hours over a month. That can be down, but you don't get to choose when that time is down. Right. That can be down during your most crucial time. I mean, a good example would be like Cyber Monday shopping and your website's down. Like those are some very valuable hours, very valuable minutes and seconds, really. So that's when it's crucial and important to think about that. 99.5 is 0.5% short of an A+, right? But it's like very consequential from a customer perspective. So looking for 99 or 3 nines, 999 is standard, but in some situations, a 99.95 or 99.99, the triple nines, is the standard that the customer is going to expect based off of how mission critical it is. And again, that's driven by context and circumstance.
That's right. And from the vendor perspective too, in wanting to kind of keep the best product that I can on the table, there are necessary downtimes. Right. So from the vendor perspective, it's often a good practice to carve out those expected downtimes and preferably have those during less busy hours, overnight, weekends, whatever that looks like, and exclude that from that availability time.
And then the other thing is, so that's the other piece of it, right? If you have 99.5, which is like 3.5 hours a month, but that's in addition to already planned scheduled maintenance. So, you might already have built in, 4 or 5 hours, potentially a month of downtime. This is in addition to that downtime. So that's really what you need to think about. The other piece that I see that sometimes people don't think about is, when is that downtime? Oftentimes we try to make sure that it's at night. I mean, that's what vendors prefer anyway. They usually do updates, things like that in the evening, so that there's less, in theory, less of a break in business for their customers. But that's the other thing is, sometimes they'll put in times. And so you need to check whether it's in, are you sitting in California and they're talking about downtime that starts at what would be, 7 o'clock your time, because it's setting it in an Eastern time frame. And so those are things that you need to look at too, is if this goes down on a Wednesday, if there's scheduled maintenance on Wednesday that starts at 7, does that work for my business? So it's a business term that you have to look at it from that perspective. But certainly then we want to make sure that, it's up and running when you need it. If you do your accounting on payroll on a certain day every month, you need to make sure that HR software is up. So that's one of the reasons we really do look and make sure that those scheduled downtime even pieces are acceptable.
Yeah, and then I think on a couple of the other, like the IP infringement representation and warranty area. I mean, so where we're gonna, if we're keeping with the tug of war theme, I mean, where there's kind of going to be the give and take is going to be from vendor perspective about what do I know, right? So I might put a knowledge qualifier on the IP, and I may be more prone to do that, particularly if I'm getting that IP from somewhere else, if there's a third party involved. The other area where kind of give and take is the scope of that intellectual property. So are we just talking about copyrights? Are we talking about copyrights and patents? Are we talking about copyright patents, trade secret know-how? We can go on and on, but that's one area to kind of limit exposure from that perspective also.
Right, and so those are kind of what we see with respect to standard reps and warranties, and this is especially a Brett mentioned, but in the software context. We'll talk about services here shortly, but then these next three that you see at the bottom of the screen, or bottom of the slide rather, are kind of more context specific and can really depend on what the vendor's providing or the solution and kind of more the specifics in each. But for example, the encryption warranty. if this is a sensitive set of information that the vendor is going to be holding, I'm going to expect certain standards, and I can compel those standards by saying, please encrypt at rest or in transit mode, and please do it to a certain standard, or just use commercially reasonable efforts, but kind of push onto the vendor that I want you to take best practices, because certainly you can say you're going to respect confidentiality and all these things, but if I want you to take certain behaviors, I can do that. The warranty encryption one with respect to software solutions that host sensitive data can be crucial.
Yeah, and I think that's very reasonable, and I think it's something that's a bit of a gatekeeping standard. If you're involved in an industry like that, you want to come to the table and offer a good solution. I think most vendors are going to have that. It's a little bit different too than Liam brought it up earlier. I mean, the legal or regulatory compliance representation warranty, that's one I just have to make, right? Because if I don't make that, the question is, are you saying that you're not going to comply with the law, which is slightly problematic. But that's
Well, and sometimes when we're talking about sensitive data, one of those pieces, the compliance with law, sometimes we also say, including for data security provisions. So if there is a standard that needs to be met because of, it's a B2C, solution, and so we have some information that's being collected, HIPAA information, information that would need to be covered under something like the warranty for that. Those are I think where we need to kind of see how we're going to fit in. Sometimes we have a data security as its own provision warranty specifically, especially if it's sensitive data, HIPAA information, PHI, PI, those kinds of things. We're definitely going to make sure have its own data security representation and warranty. And the other thing we might ask for are what kind of technology audits are you doing? What kind of security audits? Do you have SOC testing and SOC audits? Are you ISO compliant? Those are places, and even if it's not technically a warranty, we often see we often put in an audit provision depending on the type of data in the same general section.
So then the next kind of situation we see out there beyond encryption, maybe a non-virus warranty. So if the vendor is going to have certain access to my system, so there's some way that the vendor can pass viruses or malware, I want a warranty that says that the vendor will not pass those to me, that I won't end up with a virus on my system because of my interaction with the vendor.
And that's one you see fights over, and it's similar in some ways to the IP infringement warranty, and from the standpoint that that's one that I may aim to limit to my knowledge. To my knowledge, I'm not going to introduce something to you that includes a virus.
Right. And then lastly, and this is probably one of the more rare ones that we see in terms of reps and warranties, but can be really valuable, especially when a vendor comes to me as the customer and says, I can connect with your CRM, I can do something else, and this is going to be an enhancement to whatever that other solution is that someone else provides. I'm going to want to capture that in warranty and say, okay, some interoperability warranty to the extent that we can. I think I'll present that, and sometimes the vendor is open to it, other times they're not. But it's definitely something to consider if there's some kind of promise or inducement with respect to working with other systems.
Yeah, and I think that's from a vendor perspective, I think that's a bit of a question of control. Do I have control of what's being introduced into your system? Do I have control over installing it? Am I going to be able to ensure that it's in fact compatible? Sometimes you'll see a vendor pass through warranties that are associated with other third-party softwares that are part of the deliverable that they're providing, and that may be kind of a give or take in that situation.
And well, actually, I think before we go on to professional services, kind of talking about the uptime and availability warranty, another option that can be a service level agreement, which looks like just another exhibit. And I'm sure our clients, they see it just like more paper for my attorneys to read for me to go through and understand. But a service level agreement can be incredibly valuable because even though it's going to kind of be its own separate negotiation, the parties are setting up their expectations when it comes to availability, as well as maybe maintenance and support. And so they can get that hashed out before starting the relationship. But then similarly, credits can be provided or other kind of remedies can be provided within the SLA that allow the customer to put pressure on the vendor to do what they promised they would do without threatening to breach the agreement and get some kind of remedy from that as well, whether it's some kind of discount on monthly service fees or what have you. But that is a way for the parties that work together for the goals that they set up initially without blowing up the deal over something like a minor missed uptime percentage.
Yeah, it's sort of a business alignment document too. We know, there are actions and there are consequences, and we've already decided what those will be, which I think is a good meeting of minds.
So then considering we were just discussing software, reps and warranties, moving on to professional services. So this can include implementation, training, maintenance and support, maybe even on-premises work. And you're going to see some similar types of reps and warranties. They'll have some differences based on the context. So like before, we want a performance warranty, and this is with respect to services that are performed. So you'll see language like professional and workmanlike manner. A personnel warranty that the vendor has the right capacity and trained individuals to do the job. An IP infringement warranty that relates to any deliverables provided as a services. And again, legal compliance. This vendor is not going to violate the law by providing these professional services.
The other thing sometimes around the personnel, the other thing that, if it is going to be a team where you're working together heavily, one of the things that we'll sometimes do is say, if for some reason there's a team member from the vendor that's not working out, how do you replace that person? Is there a mechanism? And sometimes we find it in this section, there's a mechanism for, hey, this person, for whatever reason, is not working out. They've been on premise. They've, done something. We don't like them. It's not working. They don't work well with our team. A lot of times we'll put in a mechanism in this section that allows for customer to at least request or, require. We often see this too in our healthcare software pieces where people are going to be on site, like at a healthcare facility. We want to make sure that those we have the ability to ask those people not to be there if for some reason. And also if there is, we have some of our clients who, are chemical companies or other kind of manufacturing clients where there's definitely policies about, wearing hard hats or, whatever, if you're entering something. And so we want to make sure that we're asking the vendor to, hey, your personnel needs to comply with our policies if they're going to be on premise. And so that's a lot of times what we see those in those kinds of agreements, and also in our higher education agreements, if we're going to have somebody again on premise, because there are students and there's, issues of, FERPA information and that kind of thing. So that's another area that I know that I've seen where we put, when we're dealing with personnel, that's kind of another piece to think about there.
Yeah, when there's really sensitive issues at play like that too, sometimes you'll see vendors that will agree to have background checks performed on, various stakeholders in the project. You see that from time to time for the really sensitive data. Same kind of idea.
Right.
And then we have a question from somebody that asked about open source reps and warranties and what are we seeing in terms of trends and for those. And, open source reps and warranties, we certainly see quite a bit. We all do a lot of M&A support and due diligence, and we're definitely seeing in those agreements we've had for a while, kind of open source reps and warranties. I think that in terms of, I am not seeing it as much in current just basic software agreements. If there is a, concern, I think that it does get addressed when you're talking about title, when you're talking about indemnification provisions for, infringement and for ownership. I think that's where we kind of generally addressed it, even when it's not been specifically called out as an open source warranty. What are you guys seeing?
So I think where we might see it outside of kind of the context you mentioned with M&A support is maybe in like a software development agreement. So if someone's making code for you that will live on your system. However, understanding what open source is put into that is key. So sometimes you might see a representation warranty that is simply there is going to be no open source software provided, or if the vendor can't live with that, then some kind of process by which the customer can approve the open source that goes in. Because a lot of times there's but there's certain open source software licenses that commercial entities will want to avoid. And so they have visibility of what's being provided and the solution that's being built for them. Perhaps they can control that, because at the end of the day, a lot of times it's just finding some other code subject to another license instead of going with the license that may not necessarily align with the business objectives of the client. So you sometimes see that, but back to Chris's point, in kind of the SaaS context, that can a lot of times be covered by the infringement, but it wouldn't, to the extent that a client wants to spell it out more expressly, certainly something that could be provided as well.
Yeah, we've certainly seen it. But again, I think like Liam said, we see it more in a development context, technology agreement where you're actually paying a vendor to develop some software for you, not necessarily in just the general kind of everyday, software as a service type agreement. And then we have another question about how do you handle vendors that want to limit their representation and warranties to a specific time frame, 30 days after delivery, particularly if it's a license fee and it was kind of a one-time payment. And I know that the one warranty, especially back in the day, so when I started working in software, there was no cloud, and which really dates me, but it was all installed software. Like that was everything. So implementation was so important. Testing and acceptance was so important. Those types of clauses were so important because you were going to potentially have somebody on site, but it was your servers. It was things that the client controlled, client servers. Vendor comes on a software, premise and installs it. And, once it gets installed, does it work? And so certainly that kind of warranty where you're saying, hey, 30 days from delivery, we promise that it's still going to be working. That was much more common. And we would try to get that 30 days out as far as possible. I do not see as much of that kind of warranty when we're talking about a software as a service or a cloud-based hosted type of agreement, because usually it's live hosted, and so if it's a live and working hosted program, typically it needs to always be working. And so what we wouldn't want is, from a customer perspective, we would never want them to say, oh, it's one time. If it's a hosted piece of software, it needs to be an ongoing obligation that's going to be up and running. And so we would certainly, if we're representing the client, push back as hard as possible on somebody trying to say for a hosted solution that is only going to work for 30 days, and then we're done. And so I think that's the piece. Now, if it's an installed piece of software, that's really a product warranty. That's very similar to a product warranty, this is only going to work for 30 days. I would certainly, if they're going to allow for a product warranty, then I would also pack in to maintenance and support. There's going to be ongoing maintenance and support of that piece of software. That's where we would see, even if there's a limited, kind of product warranty of 30 days, we would then pack in and try to put in a maintenance and support type piece.
So I guess the question I have, so would you think that the performance warranty tied to documentation and specifications that we see in SaaS kind of takes the place of this time limited warranty that existed? Okay.
Yes, that's what like I said, it used to be very, very common with installed software, and it's less common now. So.
Great questions.
Yeah, these are great. I know,
Right.
This is great. Do you ever limit the amount of information that one given vendor personnel may have access to, require the development to be divided, so that no one developer has access to all of the keys of the solution? That's a great question. And certainly in terms of depending on what kind of data we're talking about. And so in terms of the question of give one vendor personnel, what information are you limiting them to? Certainly, if there's certain information, we would want to make sure that you're careful about what they're having access to, and certainly want to make sure that if they're an employee of that vendor, that they're under some sort of confidentiality or something like that. And then that's where I think you see that piece the most. And then I do know that there are some, just like I think it's KFC. They have different ingredients made by different people, and then it gets shipped to their stores and you just open the bags and mix the bags together for the secret sauce. Like, that's how it works. And it's to protect their trade secrets so that no one like franchise person would have the recipe. I think that if it's something that would be incredibly sensitive for some reason, you could certainly split that up. And I know we've got some other questions. I think we're going to keep moving along, and then we'll answer those as we go along, because I think
that would be a good segue.
Yeah, I think
Okay.
Yep. This is, somebody asked, so we were going to mention this anyway.
Not a plan.
This is not a plan, yeah. But, are you typically able to convince a vendor to agree to IP rep and warranty and indemnification, or just one or the other? And it depends on what side you're on. And I'll let you guys.
And this is a great question because we had anticipated. So I think we'll do a quick overview similar to what we did on the rest of warranties to make sure that we honor your time for this hour. And then we'll kind of talk about this question in particular, especially with respect to IP infringement, rest of warranties, and indemnification. So just a refresher introduction to indemnification. It's a risk shifting tool that you can use in contracts where certain risk might be borne naturally by one party, even though the other party is in a better position to manage that risk or should be responsible for the risk. So an indemnification is an express provision shifting that risk to the party more responsible. And what it does is it reduces uncertainty under the agreement, and it also provides more efficient management of risk. The party that's in control should be responsible, and they should bear the risk of it. A perfect example, a good case study is an IP infringement indemnification. So the vendor knows their IP, they know their solution, they know it's going into that. By providing that to the customer, if the customer is using it, they could potentially be infringing third-party intellectual property rights. So as such, it doesn't make a lot of economic sense for the customer to bear the cost of clearance for all of the vendor's clients. It also is one of the situations where the customer is likely to have limited understanding of the vendor's IP and tech. So because of that, IP infringement indemnifications are fairly common, among others, that you can also see on the screen.
Yeah, so typically the vendor is going to be in a better position to defend that intellectual property just because they're more familiar with it. So I think kind of circling back, do you see both? The answer is yes, sometimes, not often. I mean, that's a great position to be in if you're sitting in the customer's shoes. But having the customer have that opportunity to kind of get you in two places is a tough one to swallow from the vendor perspective.
The second bite problem.
Right,
yeah.
Right. And I can be in a lot better control if I'm defending it myself. So I'm going to push for that in some ways, and in other ways may want you to come after me. But economically, it makes more sense for me to defend it.
Well, and typically, if we and from a client perspective, I would rather have the client have the indemnification, because in defense piece, and we're going to talk about what's the difference between, especially indemnification, indemnify versus defend, what's the difference of those two? And then there's hold harmless, of course, and they all three have a different meaning. But those are the two, indemnify and defend are really the two that we see a lot, that we spend time discussing. And, I would rather, if I'm representing the customer, I would rather have the indemnification and defense, because I don't want my customer to have to defend a lawsuit and then themselves, and then go after the vendor for either a breach of warranty, breach of contract, right? Which is what, if we get it as a representation and warranty and not an indemnification section, then customer has to go through the whole, lawsuit, settlement, all of that, and then turn around and sue their vendor to get the money from the vendor for a breach of contract and to prove that there's a breach of contract. So so it just does depend. But some vendors, we certainly see that they say, I'll give you the rep and warranty and then come after us. I've literally had vendors say that to me on a negotiation, and that's just sometimes the stance that they take. But it does, I always think, make sense, for vendors, and most vendors provide some type of rep and warranty or some type of indemnification, especially surrounding IP.
That seems to be the starting point, is with IP. I mean, that scope expands. We're going to.
No, I was going to say, so yeah, I was just thinking, so when I, as a customer, typically receive a contract, what is the indemnification provision?
Usually it's going to say, if it's there, it's going to say that I'll indemnify you for IP infringement.
Right.
Or defend rather. Sorry. Yeah.
Right. Which defend, and we'll try to add some color to what these terms mean because they each mean something different. But defend is certainly a good option for me as a customer because it's really going to go after that situation where someone comes after me with an infringement claim, and they're going to provide me an attorney, and they're going to step into my shoes with respect to the lawsuit. And that means even if it's a meritless claim, so not something that can go to court, it's frivolous, or gets thrown out, they're going to cover the cost of that attorney. In addition to that, kind of expand the scope of protection would be indemnification, which would be compensating me for certain identified losses. And that can be a defined term losses, or it can just lay out specific losses that might come into play. So this could be beyond the cost of defending, but me hiring my own attorney to kind of analyze this issue that's arisen or other related costs. And then lastly is the concept of hold harmless. And that even kind of goes a little bit further because it can cover compensation for costs that fall outside of the realm of those defined losses that you might be getting indemnified for. And similarly, it can go at preventing direct claims between the parties or from the vendor to the customer with respect to some claims under the agreement that might arise with respect to IP infringement. So my response to the vendor is I would like for you to defend, indemnify, and hold me harmless. And I'm also going to try to expand that to be some of the obligations that are on the slides, but also to include, Meyer said this earlier, me and my family. And so that would include not just me, the customer, but my affiliates and the respective officers, directors, employees, agents, successors, anyone within my scope of responsibility that could be served with one of these claims for IP infringement, fraud, gross negligence, willful misconduct, data breaches, reps and warranties, confidentiality, etc.
And naturally, my response is going to be to limit of the indemnify, defend, and hold harmless. I want to keep as few of those as possible, right? Starting with defend being kind of my best position, and then growing to indemnify and hold harmless. And I think to Liam's point earlier about, well, who am I going to defend and or indemnify and or hold harmless? My mission is to limit that scope. And Liam and I were talking about it earlier. I mean, it's very unusual that you would. It's kind of an all or nothing thing. Are you going to just indemnify, defend, and hold harmless the licensee, or are you going to open up the scope to the rest of the family? You're not going to limit it just to officers, right? Typically, you're going to see that sort of like umbrella language. That's the all or nothing.
One or it's everybody.
Right, it's the whole family. You don't get to keep an in and out. Yeah, that's not. You don't see that very often.
No, and indemnification, especially kind of in this, we'll talk about it from the context of IP, given that we're all IP attorneys, can be incredibly valuable just given the cost of IP litigation. I mean, like this is a risk that no one wants to bear, but again, the vendor's in the better position. So that's why we're trying to seek that from them. And a lot of times, sometimes in negotiation, it requires reminding the vendor that we would like this indemnification because someone that they're seeing pushback on this is just reminding the vendor that they're in the better position to control this risk. And if the risk doesn't outweigh the reward doesn't outweigh the risk for the contract with the customer, question whether it's a good business decision to move forward with it. So that's kind of what the pushback is. And I think opening the vendor's eyes to that will help them realize the importance of it to the customer.
And I think we'll talk about how this fits with the limitation of liability issues also, to Liam's point about IP indemnification. Defending in IP cases is very expensive. And so some of the other things that are addressed in indemnification are also some of the high dollar issues, right? It's easier to have those taken care of via an agreement than a fight later on, right?
Well, and I think the other piece is one of the things that, we can have the next thing, we had somebody say, what did we have somebody say? Sorry.
Great segue.
So we're gonna great segue. You guys are
really good.
Like, making it easy on us. No, but one of the things to talk about too is when there's indemnification. One, your indemnification is only ever as good as the company giving the indemnification. Mm-hmm. So that's something to think about. Sometimes if you have a really, really small software company, if they get a couple of letters, a couple of their clients get sued, they're probably going to go under. You're going to end up, unfortunately, the customer is still going to be, in a difficult situation of, now not having a software piece, but also that they may have to defend a lawsuit. So that is something to keep in mind, that as much as we do fight about indemnification a lot of times and negotiate about it, it really is, at the end of the day, only as good as the person giving and the company giving the indemnification. with that being said, one compromise that we do see, both for data breaches and for IP infringement, is sometimes we'll have the vendor provide a solution where they say your sole remedy for IP infringement is to cover, is replacement. We'll go out and get the license for you. We'll replace it with something non-infringing. We'll cancel the contract and refund any prepaid fees. Now that still leaves the customer without a software piece, and they have to go figure it out. But that is another way that we've seen some compromised, right? Because it's not exactly everything, but it does provide a solution that hopefully is palpable to, potentially both sides. So that's one area where we've seen some compromise. And then on data breaches, one area that we've, 5 or 6 years ago, when we started putting data breach into the indemnification sections, it was completely uncapped, which is going to be our segue into limitation of liability. It would be completely uncapped liability, because right now, when we're talking about indemnification, we haven't talked about caps on things. That indemnification is considered, uncapped at the moment until there's additional language. And we were getting no pushback from vendors about 6 or 7 years ago on data breaches being, complete indemnify and defend from. We certainly get pushback now. I have more and more pushback on the data security piece and data breach piece. But one of the compromises you can, kind of have there is to outline specifically, okay, these are the types of costs that will be covered in a capped or uncapped, which are, mitigation of the risk. If, there's information, personal information that's been breached, and you have to, send everybody's, pay for Equifax or, one of those companies, for, monitoring people's, personal data and their credit scores and things like that. So, those are pieces that you could also insert to say, okay, no matter what, these are going to be uncapped, even if you later then cap some of the other ancillary, costs. So that's one place that we're seeing it. But then in terms of limitation of liability, so that's the next piece, which we spend a lot of time discussing in agreements. And there's usually 2 sections.
Right, and just to step back just 1 second, the indemnification kind of limitations with the different options, because it dovetails well with the limitation of liability. But when a vendor is coming in and saying, we'll either give you a license, seize an infringing product under an IP infringement indemnification, or replace it, or terminate the agreement relative to that solution and provide a refund, that can be generally acceptable, because at the end of the day, the vendor is allowed to, or is able to control the infringing use that they might be responsible for. And so long as the customer is made whole, perhaps they don't care. Where you might consider, though, limiting that ability to terminate a refund is if this is a mission critical piece of software, not in a very competitive software solution space, or really difficult to transition to someone else. You may want to limit it to, this is, you are either going to obtain a license or modify it so that it's not infringing, and there's going to be no refund, no termination. You have to figure out that's on you, vendor. And that might make some kind of provision in the indemnification that says this is the exclusive liability with respect to infringement more palatable for the customer. But that kind of statement goes into limitation of liability, which we'll discuss now. So to provide a brief overview, similar to indemnification, limitation of liability is a risk shifting mechanism. And really, it's 2 forms. You can have a waiver of indirect damages and a cap on aggregate damages or direct damages in particular. To kind of conceptualize it, what's happening is when there's no limitation of liability, direct and indirect damages can arise from a contract. That could be an enormous universe of liability to the extent that it's disproportionate to the value of the transaction itself. So especially in mutual limitation of liability situations, the parties come together and kind of define the outer edges of the scope of liability, which they'll be responsible for, to make it more palatable for both if something were to go wrong and what they could be on the hook for. So in those situations, we'll see exclusions for indirect liability that are ones that are liability that wouldn't necessarily arise in the ordinary course, and then some kind of limitation or cap on direct damages, whether it's tied to a specific amount potentially X number of months associated with fees payable, or maybe insurance limits. It all kind of depends.
Yeah, and I think that has moved the rope a little bit in that direction. I mean, I think oftentimes the starting point is even the vendor's liability, the sort of one-sided limitation of liability, because it's their form, and it's limited universally to something like 6 months fees paid or something
12
like
months,
that.
yeah,
12
three.
months
I've seen
paid,
three
as low
recently.
as, yeah.
3 months fees paid,
which is often going to be insufficient from a customer perspective, especially for one of these sort of high dollar types of liabilities that you could be exposed to.
Yeah, and one of the things too that we've seen is, and the reason we typically try to say paid and payable is because if you think about it, if there's a data, you sign your contract, you pay maybe an upfront license fee, or you pay, where it's going to be a monthly subscription type or annual subscription. So you've paid, some amount, but maybe not what would, you're in a 5-year contract, so maybe not all 5 years worth. Day 2, there's a data breach. You've paid a fifth of the contract. So we say, typically, if we're representing the customer, we'll say paid or payable. So that way, it's the full amount of the contract, not just what you've paid at that particular date. But usually, we typically see a 12-month cap. That is, I would think 80% of the contracts I get, it's 12 months fees, paid.
Right, and there's a lot of different levers that can be pulled with respect to limitation of liability to either position the customer in a situation that they want to be respective to potential liability to themselves, but also for the vendor. And those can include exceptions to whether it's the waiver on indirect damages or the cap, or finding a way to introduce a super cap of some sort. And a lot of times this is driven for the vendor, I think, speaking on behalf of the vendor, from the business side, because it's a business decision on how much risk they want to be exposed to. So for example, if I were to pose for an exclusion to indirect and direct damages cap IP and data breaches, I'm not sure how the vendor's ready to respond to that, because who knows if they've thought about it or if they're willing to take on such a big risk. Right. So if I did that,
when they may go back, you may go back and check with your risk management group and that sort of things. And what we used to see, I see it less and less. I don't know about you all, but one thing I was going to bring up is the sort of insurance. Sometimes we would limit it to an insurance amount, and there's a lot more pushback on that these days, right? And that so that you all are seeing that,
right?
Yes, yeah. I'm seeing it too.
Is that driven by policies?
I don't know. But one I will say is, yeah, it might be driven by some of the policy amounts, because but that can be a compromise in some way. We typically do, especially depending on the type of software, like we'll typically put in an insurance provision that says, hey, vendor, you promise that you will definitely have, cyber liability insurance up to $5 million or up to $3 million or whatever. And so one of the things we do, sometimes then try to tie in, those assurance amounts. What I've seen when they're doing that, this happened fairly recently, is somebody actually tied it to the amount that would be available to the customer, not actually the amount that's total that's available to the vendor. So you do have to really read those sections when they're talking about the insurance piece, because you want to make sure that it's not just, because yeah, it sounds great if they have $3 million of cyber liability insurance, but if that is going to get split between all of their customers, now you only need, maybe you're at $100,000 that you could recoup.
Especially if we're talking like insurance limit for IP infringement, right? Like presumably this IP infringement is across all of their customers potentially exposed to it. So I mean,
same with data breach.
Exactly. So all these you're going to be getting a small sliver, and it's key to figure out how that's kind of playing. So sometimes a vendor might say, sure, we can tie to insurance limits, but only your portion. But you have to really appreciate how small that can be.
At the end of the day, how small that could be. And then, we really often, when it comes from the vendor, we do look and see, is it mutual? Is it one-sided? I mean, obviously, when we write these for the vendors, a majority of the contracts we get, sometimes it's mutual in terms of waiver of consequential damages, incidental and consequential damages, but then it is the vendor only is the one that has the cap on the rest of it. So that means the customer would still have uncapped liability for any of its breaches of the agreement, with no limitation or cap on that liability, and the vendor gets to cap all of its liability. So that's an area, to pay attention to. And then, as Liam said, one of the solutions that has come up, I feel like, in the last few years, from when we were able to get unlimited liability and get an exclusion to the cap for data breaches, is the super cap concept that's really come around in the last few years, which is, okay, the vendor needs to still be able to limit its risk in some way, either because, sometimes that's just a part of, business and doing, cost of doing business. So what we'll do is we'll say, okay, for these particular ones, not fraud and, willful misconduct or negligence, gross negligence, not for those are still uncapped usually. But for data breaches and IP infringement, the parties are going to agree at, some dollar amount, or some X factor of the amount. So instead of the 12 months fees paid, maybe you get 5 times 12 months fees paid for this small bucket of things. And that's one of the super cap concept that we've really seen in the last few years as a try to compromise. And then, at the end of the day, it is always a business decision, right? What risk is each party willing to take? And if you get a vendor that just says, absolutely not, this is what it is, but you really need the solution as a customer, then sometimes the answer is the customer needs to go and get more insurance to cover the issue and the gap that there could be if they really need that solution. And maybe they don't have a lot of leverage, and the vendor's like, take it or leave it. That's the other place that sometimes the customer is going to have to go out and make sure that their insurance will cover a gap that isn't going to be covered by an indemnification from the vendor.
And Chris, to kind of revisit that super cap, so it's interesting because it's a nice compromise, but there's situations where it may not make sense to even have a multiplier of the monthly fee. So for example, if we're going from a cap of X number of fees or whatever amount and uncapped, and the monthly fees are, let's just say a number of $100, right? 3 times that isn't gonna change it. So I guess is there an alternative to just magnifying the monthly fees that you see as well?
Yeah, so sometimes we'll actually, again, put in insurance amounts or put in an actual dollar amount, $1 million, or some actual number. We do see that as well, where we will just put in a number. So that's the other piece that I see, at least. I don't know what else you guys are seeing.
I like when it's a number because it's very concrete for everybody.
Right.
And it seems to make for a simpler negotiation in some ways when you're talking about the kind of high dollar limits. And just for ease of sort of organization, oftentimes, because we covered all of these items in indemnification, it's really easy to tie the contract together by excluding indemnification events. Sometimes if that's typically negotiating against myself here from the vendor perspective.
Did a great job.
But that's one way to make sure that all of those high dollar amounts covered.
Yeah, and one thing you have to be careful of is, so sometimes in indemnification you'll have, breaches of representations and warranties. So then if you have in your warranty section, IP or data breaches or, warranties for those, and then you go over to the indemnification and say, okay, indemnification for reps and warranties, breaches of reps and warranties. So then you don't add in data and you don't add in, data breaches, and you don't add in indemnification IP infringement. The problem with that, though, is if the vendor, when they come back, take out indemnification or take out that breaches of reps and warranties, because I don't see getting those very often, to be honest, on behalf of the customer. So often then the vendor will delete that out if we add it like that. You just have to remember, now you're missing a bunch of things from indemnification because all you said was a breach of rep and warranty. So that's why we do sometimes to be very specific about making sure data breaches and IP infringement are in there. So I think, and then how does that work with the limitation of liability? These three sections are really tied together. And so you really have to make sure that you're on both sides. When something changes in the limitation of liability, how does it affect the warranty section, or does it? How does it usually affects indemnification, which can then affect warranties, which is why when when we do training and we talk about it, we really do hammer these three sections in terms of trying to make sure that you're paying attention to the moving parts of them.
Right. And it helps a lot, I found, on both sides to talk through specific events. Okay, we all have our fears of what goes wrong if this contract doesn't work out. And that's where you can really start to see how the three fit together. Okay, there's a breach of irreparable, what impact does that have on an indemnification event versus limitational liability? But those specific examples help a lot to see how it plays out.
Yes. And then we had a question that talks about typical damages and kind of what's, are there damages that you should ensure are recovered and categorized as direct? I typically do not like or see when you try to define it, because I think you could have this laundry list and you might miss something. So I would rather, if there's direct damages, those are typically going to obviously be any kind of impact, like if there's a judgment or a settlement, or you have to pay a licensing fee, or those kinds of things are all pretty easily direct. But I have asked this question, almost exactly same question, to some of our litigators, because I was curious and I wanted to kind of talk, and I was having this really hard negotiation, and so I went to one of our litigators and I was like, hey, what do I need to make sure is defined or not defined, or these things? And they're like, we're going to litigate it all anyway. If it goes to litigation, I'm going to argue, depending on what side I am, that everything's a direct damage and nothing, or everything's an indirect damage. So there is that. And so we do want to, make sure that we're at least have the right as far as the, customer to get recovery of direct damages. But at the end of the day, if it goes to litigation because it's that bad, our litigators are all going to rip it up and start over anyway.
And the definition of indirect consequential damages can vary by jurisdiction too. So
Absolutely.
It depends on where you end up and how that's going to shake down.
Yeah, because one court, I would say recently, but I think it's actually not recent at all anymore, found that some of the data breach, some of the ancillary things that happen around a data breach, even though the data breach itself was covered by the vendor, it actually, a lot of the mitigation pieces of it, they found to be indirect damages. So, for instance, the cost to enroll all of the customers in a credit checking piece of, that at one of the companies, that was considered actually an indirect damage. In my head, that would absolutely be direct damage because it's what you have to pay because of the breach. But because it wasn't specifically harm to the company solely for that breach, it was found to be indirect damages.
And I think that could be a good example, say like incidental damages, like
right.
Certain losses you have to take, or certain expenses and costs you have to incur to prevent further losses, right? Like credit scoring for data breach helps ensure that future issues won't happen to those that are affected. So I can see both sides, but to your point, it feels like it stems pretty directly from the incident.
Yeah, but it was considered an indirect damage in a jurisdiction. And so, that's the other piece. And so then because, like in this, there was a waiver, no party is liable for those, the vendor didn't have to pay that piece of it. So I think we're almost at time. Thank you guys so much for joining us. I think there might be a few questions we didn't get to. We will certainly circle back with those folks. But thank you, first off, everybody, for attending, and thank you for the questions. They were great, and I think really helped spur some of the discussion. Anything else you guys want to add to tie anything up?
I got nothing.
No, thanks for spending your lunch hour with us.
All right. So as a reminder, this program has been approved for legal education credit. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course number, will be emailed to you tomorrow. Be sure to complete our short survey. Again, this is how we ended up with this session, is because people said we'd really like some deep dives into the contracts instead of just the overviews. So thanks again for your suggestions. We have another series next month, hopefully, and on false trademark issues. We have a lot of scamming going on in the trademark world right now. So that's going to be Brianna Schonenberg out of our Milwaukee office is going to be having that. And then Liam is going to present with Eric Rakestraw, who's in our St. Louis office, on some open source software issues in October. And then I think we're going to have a copyright and trademark roundup of the year in September. So please look for those, and thanks again for joining us today.